So if domicile's the key linchpin to your argument, and I take it that it is, do we look at how domicile was understood in 1868, or do we look at it how it's understood today in context of the INA?
The 1868 understanding, I'm not aware of a strong difference between those.
Well, here's where I'm going with it. I'm just working within your argument for a moment. Today, you can point to laws against immigration that are much more restrictive than they were in 1868. We really didn't have laws like that we do today until maybe 1880. So if somebody showed up here in 1868 and established domicile, that was perfectly fine without respect to anything, any immigration laws. There they were. And so why wouldn't we, even if we were to apply your own test, come to the conclusion that the fact that someone might be illegal is immaterial?
I would first cite Wong Kim Ark on that point, because Wong Kim Ark says you're...
Well, I'm not sure how much you want to rely on Wong Kim Ark.
But there is a statement in there that says, so long as they are permitted to be here. So Wong Kim Ark, keep in mind that by the time they decide Wong Kim Ark in 1898...
but that's 1898. Now I'm looking at 1868, you're telling me is when I should look, and the test for domicile. And the stuff you have about unlawfully present, it's like Roman law sources you're going to.
First and second restatements as well, and decisions of this court.
So it wouldn't be the INA that would control whether you're capable of having domicile. It would be whatever the law was in 1868.
I think that this is addressed by my exchange with Justice Alito from earlier, which is that this concept, jurisdiction, baking in allegiance and domicile is applied to.
So Congress could continually restrict who may lawfully be present more and more, and you'd say that would be incorporated into it, even though you're telling us to apply the original meaning of 1868.
The original meaning of domicile. And so the question is there any argument that the framers intended to preclude Congress from dictating who can and who cannot establish a lawful domicile here? I don't see any evidence of that in the congressional record, so it's a natural extension.
Whose domicile matters? I mean, it's not the child, obviously. It's the parents you'd have us focus on. And, what if, is it the husband? Is it the wife? What if they're unmarried? Whose domicile?
Well, in the executive order, it draws a distinction between the mother and the father. And it's really the mother's domicile. I think that would matter.
Well, but 1868 matters, you're telling us. So what was the answer?
The 1868 sources talk about parental. I'm not aware of them drawing a distinction between mother or father, but they say the domicile of the child follows the domicile of the parents.
And how are we going to determine domicile? I mean, would we use contemporary sources on what qualifies as domicile in a state, or do we look in 1868? And do we have to do this for every single person?
And again, I don't see a strong distinction between those because, of course, domicile is a high-level concept, has been pretty consistent over centuries, which is lawful presence with the intent to remain permanently. That domicile, when you come to a new nation, you say, I'm here to stay, you become part of their political community, and you become akin to a citizen. And that's reflected very strongly in the case I cited before.
And just to circle back to Justice Kagan's point, it's striking that in none of the debates do we have parents discussed. We have the child's citizenship and the focus of clauses on the child, not on the parents. And you don't see domicile mentioned in the debates. The absence is striking.
I think the 19th century sources would say a newborn child lacks the capacity to form a domicile, so they're imputed the domicile of their parents. So I don't think they would have seen a distinction between children and parents. And I point out that their position, like ours, is forced to look at the domicile of the parents because we look at the exceptions that they accept, like
I'm talking about
tribal Indians and so forth.
I'm talking about in the debates over the 14th Amendment and the Civil Rights Act. It's striking that these concepts aren't discussed in them.
I think domicile is discussed. I mean, it's brought up in many...
Allegiance, jurisdiction, complete jurisdiction.
Well, I mean, here's just a few examples. Page 1679 of the congressional record, President Johnson vetoes the first version of the Civil Rights Act, and he says, I can't sign this because it would extend citizenship to the children of, quote, all domiciled aliens and foreigners, even if not naturalized. And you have all the other sources we cited that say, this is a deeply rooted 19th century understanding. It's reflected in the Venus. It's reflected in the Pizarro in 1814 and 1817. It carries through the 19th century, and This court is talking about it in 1892 and 1893 when it's discussing the Chinese Exclusion Acts. Domicile is the key concept that creates allegiance. That's
General,
General, you said in your reply brief that the children of slaves who were brought here unlawfully, in defiance of laws forbidding the slave trade, would in fact be citizens. And we can imagine that their parents were not only brought here in violation of United States law, but were here against their will, and so maybe felt allegiance to the countries where they were from. And you say that the purpose of the 14th Amendment was to put all slaves on equal footing, newly freed slaves on equal footing, and so they would be citizens. But that's not textual. So how do you get there? You say it in just a few sentences, so can you elaborate?
Sure. If you look at I think if you look at the 19th century sources, what you see is that even though their entry may have been unlawful, 19th century antebellum law never treated their presence as unlawful. In fact, quite the opposite. One of the amici, in fact, points to like a Mississippi statute, which probably is replicated throughout the South before the Civil War, that says slaves in Mississippi have an indefeasible domicile in Mississippi. In other words, even if they run away, if they get away, Mississippi says, nope, you still live here. Right? And so it would be astonishing, in other words, for the opponents of the 14th Amendment to say, oh, these people were not domiciled and therefore it goes the other way, because actually U.S. law, even if they were brought in illegally and through an illegal slave trade, once they were there by
well, their intent is to return as soon as they can, let's say. So they're here, they're resident, and maybe under your theory, which says, well, lawfulness for a different purpose, but they're here, they're resident, let's take your assumption that they're not here unlawfully. But let's say they don't have an intent to stay. They want to escape and go back the second they can. Are they domiciled?
Under the 19th century law, I think this is the flip side of the hypothetical that we were talking about earlier. Under 19th century law, they are treated as domiciled in the United States, so it would be astonishing. And the debates in the congressional floor talk about not this specific case, but to say, look, slaves who have been forced to come here and have been here are lawfully domiciled here. They don't use the ways domiciled like they use allegiance. They say they don't have allegiance to, once they've been forced to come here, they don't have allegiance to any foreign or African potentate, and therefore they're...
General, that goes
how would that apply to the children of illegally trafficked people today? Would the same reasoning apply?
It would turn on whether the parents are lawfully domiciled in the United States.
So if they're brought in illegally, but then they choose to remain and they want to remain and they're domiciled, you would say that their lawful presence is not dictated by whether they were brought here lawfully or not. And that's different from someone who, say, crosses the border unlawfully.
Yeah, I think it would turn on whether their presence is lawful.
General,
in other words, obviously there may be many other important things that could be done to assist people like that. The question is, if they give birth to someone in the United States, that person naturally a citizen, that would turn, based on the original public meaning of the clause, on the lawfulness of their presence. Are they domiciled?